May it please the Court, I appear with Ms. Ruchi Parek on behalf of GALBA, the Group for Action on Leeds Bradford Airport, acting for Mr. Nicholas Hodgkinson, Mr. David Wolfking's counsel with Mr. Peter Lockley, Ms. Stephanie David and Ms. Celia Reynolds appear for Possible, the other claimant, and Ms. Galina Ward and Mr. Andrew Bias appear for the Secretary of State. Given the short hearing that we have today, I will address the Court for 40 minutes on GALBA's 3 grounds, which cover the same territory as Possible's grounds 1 to 5 with some differences of emphasis. Possible will then be able to pick up some of those differences of emphasis, and then we'll address the costs issue as well in around 30 minutes.
Well, hold on just a moment. Firstly, so that your clients know, we have had the opportunity and have taken it to read all the papers in this case very thoroughly, more than once. So it's not a question of just hearing the oral argument. We have actually read all these documents very carefully. And secondly, in terms of when you say the cost issue, I assume you mean the application of the R House limit. We think we ought to hear the permission application first, see where we go on that, retire and just see where we go, because depending on what we do about permission, that may or may not affect costs. So let's deal with the substantive hearing first.
Well,
or I think substantive hearing, the permission hearing.
Yes.
Right,
Happily,
so you're going to do GALBA.
Yes, happily that doesn't affect the GALBA's 40 minutes, so I'll start. And if I may, it seems to me, given the issues in which the Court was interested, that it's most sensible for me to go effectively backwards through GALBA's grounds, starting with ground 3 and then ground 2 and ground 1. And I'm aware that that means that I'm starting on a premise that is different from GALBA's overall case. But given the indication from your Lordship about the extent of reading...
Just to be clear, that indication was about why the Secretary of State was being asked to attend, but the PTA adjournment order did make it clear that you are asked to address all grounds.
Correct, and I shall do so in the requisite detail. But I'll begin on ground 3, which is on the basis that the consultation was not on aviation decarbonisation generally, but was on a narrow question of decarbonisation without any demand management. Did the judge err in the ways that GALBA has set out in the ground of appeal? If I can ask the Court to turn in Her Ladyship's judgment, Mrs. Justice Lang's judgment, to paragraph 79 first on page 489. And I'm going there just to identify, as the judge did in her judgment, the timings of the relevant Secretaries of State being in office. So the Secretary of State for Transport, Grant Shapps MP, was in position from July 2019 to September 2022. And for the purposes of ground 3, those are the key dates. And then the other Secretaries of State dates are given there. If the Court can then go further up in the judgment to 66, that's on page 485. It starts at the top with the decision to publish the Jet Zero strategy. So this is the point in Her Ladyship's judgment where she's gone through the consultation and what took place before that and during it, and the document on which consultation took place. And she's now getting to the decision to publish the Jet Zero strategy itself. And she refers there to a 2022 ministerial submission, which was put to the defendant and that Secretary of State, Shapps, and his aviation minister, to seek the agreement to the Jet Zero policies and approve the publication, and to publish the summary of consultation responses. And then the judge sets out the summary consultation response document, which was appended to that ministerial submission. And if the Court wants to see that in the supplementary bundle, the easiest place is page 267. I don't ask the Court to go there because it sets it out. But at 267, the published version
Yeah.
of this document is set out in
Yeah.
the supplementary bundle. And the judge is there picking up the response that is given under the heading demand management and sets out verbatim what is in the document. That there weren't direct demand management proposals included in the consultation, the measures were raised and responded to, and then a few paragraphs kind of put together about what the responses were and what they'd said. With that in mind, I turn to, because this is the first place where it might have been raised by the judge, what the Secretary of State had said about this material. And if the court can go first to page 397 of the core bundle, this is in the Secretary of State's skeleton argument before the court. And the court will see paragraphs 51 to 52 picks up points about this response document. And at 51, there's a criticism made, picked up by, from the possible case about the timing of the response document. And the Secretary of State asserts there that it must be assumed that the defendant, i.e. Secretary of State Shapps, read the material that he was provided with. And then paragraph 52 picks up both claimants' arguments that there was no conscientious engagement with the substance of the consultation responses, of failure to grapple with the point. And the Secretary of State says two things. As explained above, there was no obligation to carry out any engagement or grappling, and in any event, the submission is not correct. The response document set out why the direct demand management measures have been excluded, having regard to the importance of the aviation sector to the economy, etc., all the points that were there set out. So that was what was in the skeleton. At the hearing, and this is captured in paragraph 62 of our skeleton argument, which is in the updated version with the annotations and the references put in on page 19 to 20 of the skeleton, so paragraph 62.
I've got one dated the 12th of June 2025 is the one that I've been working from. I've got different versions.
Yes, so that I hope that's the one that has the authorities bundles, the supplementary bundle and the core bundle references in it. Right. That's correct.
Yeah.
And that records that during the oral hearing, and for the first time during the litigation, the defendant conceded. I don't say that there was conscientious consideration of the responses in 2021 or 2022. It was not put to
Sorry, where are you reading?
So this is the bottom of the page, paragraph 62, bottom of page 19. Under the heading, the defendant's concession that the constitutive responses on demand management were not considered.
I'm sorry, you have to give me, I'm working off a different version, I think. What paragraph number?
Paragraph 62.
Thank you.
If it is...
Yeah, I've got it.
You've got it. Paragraph 62. So there, the concession that was made in the hearing is recorded, that the Secretary of State didn't say there was conscientious consideration of the responses. They were not put to Secretary of State Shapps with any suggestion that he change his mind on the basis of them. That did happen in 2023. And in the hearing, after the submission had been made, and there was a short adjournment, the judge came back and clarified on the basis of those paragraphs I took the court to in the Secretary of State skeleton, 51 to 52, clarified that what the Secretary of State was submitting was that there was no argument that Secretary of State Shapps adequately considered the demand management or direct demand management responses in that response document when they were put to him. And the defendant clarified the deep dive that's set out in the judge's judgment was done, but Secretary of State Shapps was not presented then.
Right, the position is the Secretary of State did not consider the argument that direct demand management, by which I understand you mean limits on flights and so on, were considered as part of the consultation analysis.
Correct. There was no reliance by the Secretary of State on conscientious consideration.
The point that's put against you is he wasn't consulting on that, and therefore he doesn't have to consider responses to things that he's not consulting on. That's what's said against you.
But so the respondent has confirmed in the note put before the court, paragraph 3.3 and paragraph 9, that was what was said. So if the court then goes back to the judgment at paragraph 66.
Yeah.
There the material is set out, as we've seen, but that is not recorded. At this point, that's not recorded. And then paragraph 69, first sentence, the defendant agreed the recommendations for the submission and further work. That's recorded. But of course, that agreement was not based on any conscientious consideration of the demand management responses. At paragraph 72 on the next page, the judge rightly records that officials had done the in-depth analysis on direct demand management, and that's what had been clarified in the hearing. But there the concession is not recorded either. And then the judgment picks up something I'll come back to in paragraph 75, which is question 2 of the consultation document on the illustrative scenarios, and I will come back to that. The judge at then paragraph 78 of the judgment sets out in detail the overall responses on demand management or direct demand management. I'll come to the difference between those terms when I deal with ground one. In paragraph 78, again, without recording the concession that was made. And then the judge starts at paragraph 118 of the judgment with her conclusions. That's on page 502 to 503, on the consultation responses. And she starts with the fact that there was no statutory duty to consult, that's paragraph 119, and says that the defendant had a broad discretionary power to formulate the strategy and then choose the matters on which to consult, 120. And then goes on to deal with the authorities. I'll come back to those in a second, if I may, but I want to look at the judge's conclusion before I deal with what the authorities say. So the judge then concludes on this particular point in paragraph 134. This is on page 510. That the consultation responses and the defendant's response to them are summarised, and that's what we've just looked at together. And the judge says that she, in her view, that they show conscientious consideration of the consultation responses took place, direct demand management lawfully outside the scope of the proposed Jet Zero strategy and the consultation, no obligation on the defendant to reconsider his view on direct demand management in light of that. However, officials, so that's the officials again, did carry out an in-depth analysis. A detailed response, including direct demand management, was provided in the summary of consultation responses, but an earlier version wasn't provided. And then this line: I have no reason to doubt that the defendant and his ministers considered all the consultation responses. Mm-hmm. So just pausing there. If by that the judge meant that Secretary of State Shapps considered all the consultation responses, including direct demand management, with conscientious consideration, which is, I would say, the most natural reading of that paragraph, then that is incorrect, because that is directly contrary to what the Secretary of State had submitted to the judge and to what the judge had clarified with the Secretary of State was the position. She had very good reason to doubt that the defendant and his ministers had considered the consultation responses on direct demand management at all, because she had been told that they had not. Assuming
that that's right, the question that's put against you is it doesn't matter.
Yes.
Because he wasn't consulting on that.
Yes, and it doesn't matter for two reasons, which is it's said. And the first reason is, and this is the assertion in that paragraph, that there was no obligation on the defendant to reconsider his view on direct demand management in light of the consultee responses. And that engages with the authorities, which I said I would go back to. And effectively what Galba's case on the authorities is, and my submission is that this has a realistic, not fanciful prospect of success.
Well, what is the submission, first of all, and then we'll assess whether it's got a realistic
prospect. As an argument.
We haven't yet got to your
yes, as an
submission.
Argument. Well, your Lordship has read the skeleton argument, as you said, so you have an idea of what's coming. But if you look up at nettleship in the judgment, we can start there. That's paragraph 127 of the judge's judgment at 508. And there the judge extracts or mentions the part in nettleship where there's reference to guidance, saying that's no requirement and it would be positively misleading to consult on adopting options which are not genuinely under consideration. And Galba and Possible's submissions about that, which were in the reply, and I can take you to that if you want me to, but which also pick up what they said in the authorities bundle, and I just need the one page of the authorities bundle. That's page 272 in the authorities bundle in nettleship. It's sidelined red, paragraph 57 on 272. At the bottom, that's the guidance. Decision makers can consult on a single option or a preferred option. This is the part that Galba and Possible emphasised. So long as they are genuinely open to influence. Point one. There's no requirement, and it would be positively misleading to consult on adopting options which are not genuinely under consideration or unrealistic or unviable, but it may be necessary to provide some information about arguable alternatives. Qualification number 2. Both those qualifications to that blunt statement about it being misleading to consult on options that are not genuinely under consideration or unrealistic or unviable were highlighted to the judge, are not included in her judgment where she sets out nettleship, and in my submission are not engaged with in her judgment, because they go directly to the correctness of the assertion that was made that the Secretary of State was under no obligation to reconsider his views, given the narrowness of the consultation.
So you said 2 qualifications. Can I be really clear what you're saying? Are you saying this is a case where it was necessary to provide some information?
Yes.
What else are you saying?
And it is, so there's 2 things. The first bit, that's necessary to provide alternative information, goes to grounds 1 and grounds 2. But ground 3 is the first bit. So long as they are genuinely open to influence.
On the thing they're consulting about?
No.
Oh.
Genuinely open to influence about their preferred option. And that must mean that the preferred option is not the correct option and a different option should be preferred.
But doesn't that still beg the question about what you're consulting on?
Yes. So what the court has just seen and what happened in this consultation, and we can go back and I'll go in detail.
We're familiar with what happened. I'm trying to understand the submission.
So I'll go in detail to what the consultation document said, which goes to grounds 1 and grounds 2, which in our submission gave a reasonable reader the impression that direct demand management.
We'll come back to that. Yes.
But taking the document on its face.
Assuming this was a document that says we're not consulting about limiting demand management, or we're not consulting about demand management, we're consulting about alternative technological solutions to carbon emissions.
We have a preferred solution. It wasn't. It didn't say that.
No, that's what they're consulting about. we can give it whatever label we want, but the subject matter of the consultation is technological alternatives to deal with carbon emissions.
Yes, and some demand management and influencing consumers.
Influencing consumers, yes.
Yes. So that's what we're consulting on. This is our package. Here are the principles that underlie the package. Here are the 5 policy levers that we're going to use.
So why then do they have to consider a different proposal?
Because...
That they're not consulting about, which is demand management.
Because, first of all, there were elements of demand management that were part of the consultation. But secondly, it is only fair to consult narrowly in this way, to consult on a specific set of proposals that omit alternatives that were previously open to consideration. And I think it's accepted, and that's on the basis of the 2018 document.
Only fair to consult narrowly
if the decision maker is genuinely open to persuasion that the alternative, i.e. what's not consulted on, should be adopted. That's not to go behind or improperly to widen the ambit of the consultation. That reflects the gunning principles on when it is fair or unfair to consult in a particular way or to deprive consultees of an opportunity to persuade the decision maker that is doing the consultation to adopt a different approach.
Well, if you're consulting on a proposed policy and you want to say, no, don't do that policy, do another policy.
Yes.
So you should be consulting on another policy.
Not that you should be consulting on another policy, but that you should, when you take into account the consultation responses, open your mind to consider a different policy approach should be included.
But why? He's already decided he's not going down that route, rightly or wrongly.
My Lord, all the cases, so we've looked at nettleship, but if your Lordship turns up paragraph 68 of the skeleton argument...
But you don't take us to a key Court of Appeal case called MP, when they went precisely through this in MP, when the Secretary of State decided to consult on 2 bits of something to do with provision of NHS services to immigrants, and didn't deliberately decide to consult on 2 other bits.
Yes.
And the Court of Appeal said, no, it's for the Secretary of State to decide on what he consults on, and if he consults, he's got to do so fairly.
Yes, and there's
but
Mosley...
You're saying it's necessary to consult fairly if you say, I am consulting on technological solutions to carbon emissions.
Yes.
You must be prepared, because you've agreed to consult on that,
yes.
to consider suggested alternatives to that policy.
In these circumstances. And that's the difference between MP and other cases like Mosley, where the consultation was narrow, but the Supreme Court said that that consultation responses...
I need to understand what in these circumstances...
Yes, so I'll get to the circumstances in a second, but maybe I should also just absolutely nail down what the authorities say.
Right.
Because it's not right that the authorities, as the judge herself said, all point in the direction of the authority that your Lordship has just mentioned. Because as we set out in our paragraph 68, Mosley in the Supreme Court, paragraphs 28 to 29, Roussel, paragraphs 30 and 71, and Nettleship, all point in the direction that it is, where there is a consultation on a preferred option, the circumstances can demand that fairness requires answers that say you should take a different course to be considered, and to be considered conscientiously.
And so we're back to what in these circumstances mean.
My Lord, yes. And that is where this ground overlaps with grounds 1 and grounds 2. And there are effectively 4 reasons why, in this consultation, fairness demanded conscientious consideration of demand management. But just pausing there.
No, 4 reasons why fairness demands consultation or consideration of demand management.
Yes.
Using that as a shorthand.
Yes. And just pausing there, the judge doesn't engage with any of these matters in her
The 4 reasons are?
And those 4 reasons were all put before the judge.
No, what are they?
In the court below. So, the first reason is, and this is picked up at paragraph 41 of our skeleton argument, that demand management was an option of central significance which had been set aside.
Hang on.
So that's paragraph 41 on internal page 13.
And you'll have to disentangle what that means.
Yes.
An option of central significance.
Yes.
To whom? Not to the Secretary of State, because he's ruled it out.
Well, it had been of central significance to the Secretary of State's officials.
Yeah, but they're not the minister.
Who had previously included it in the published consultation document 2018 document.
But the Secretary of State said he didn't want it.
Then it was an option of central significance as a result of the engagement with industry, and I'll take the court to this in a second, as a result of engagement with industry, where the Jet Zero Council CEO and the Chief Operating Officer of Heathrow had said that this consultation, the Jet Zero Strategy consultation, needed to consult on demand management as a backstop or a last resort in order to add credibility to the overall strategy and and I'll take the court to that in a second. Third, that the aviation body, Sustainable Aviation, had also indicated that demand management should be consulted on. And fourth, that government bodies, other than this Secretary of State, i.e. HMT and BAYS, had also stated that demand management should be consulted on. And I suppose I'll add a fifth one, which is that it was very clear that as far as bodies outside of government, so like the Climate Change Committee and the public, they had made demand management a central aspect of both the Climate Change Committee's advice.
That sounds like an argument that he should have consulted on it.
Yeah.
No.
It's
absolutely open. It's the context.
The fundamental objection you have is to his earlier decision not to.
Not on ground 3.
Take that option.
On ground 3, it just
you've
assumes.
just linked into grounds 1 and 2, so they are linked, aren't they?
Well, either I can pursue the context within which.
But give us your 4 reasons. In fairness, you say it overlaps with grounds 1 and 2, but you're accepting that on this hypothesis we've got to a situation where it was not carbonisation generally, it was technological.
Demand management specifically.
And you're saying there are circumstances which shows it was unfair.
Yes.
And you've given us an indication that there are 4. One is that you regard demand management as an option of central significance.
Yes.
Not simply that he should have consulted about it, but even if he decided not to consult about it, he had to have regard and assess substantively the points made about it. So what are your other 3?
Correct. And then, as I ran the court, let me take the court to the documents, but as I ran through them, they were the information that had come back from the Jet Zero Council and the Heathrow COO.
No. The 4 reasons, not the subset. I'd just like to have a note for the moment of the 4 reasons. You said there are 4 reasons why fairness demand consideration of the demand management.
Yes.
One is central.
Yes, one is central thing.
And you've got a number of people there.
No. Forgive me. Separately, even if it's not a central tenet, if it's not a central option, separately, all this contextual information was there, which was before the Secretary of State, i.e. the Jet Zero Council, that's number 2, the Climate Change Committee, that's number 3, the other government bodies, that's number 4. All of those don't just go to whether this is a central option, but they go to the key factual context within which this consultation is taking place.
So I got my note. Number 1, I've written demand management as an option of central significance, and you've given us a number of reasons why it was. But some of those
are freestanding.
A freestanding 2. So could you just give me a freestanding 2, 3, and 4, please?
Correct. So freestanding 2 is the general advice that had been given to the Secretary of State in the run-up to the consultation by, let's say, independent bodies. So that's the independent aviation bodies, the Jet Zero Council and Sustainable Aviation, and the Climate Change Committee.
Yeah.
So let's make number 2 the independent bodies.
Yeah.
Let's make number 3 the other parts of government, so HMT and BAYS, and their concerns about that. That's number 4. And then number 5. Yes,
that's number 3.
Yes.
One is demand management as an option of central significance.
Yeah.
2, general advice prior to consultation by independent body. 3, views of other government departments.
Yes, and 4, that this is an environmental consultation.
Yes.
And as a result, engages the principles of fair public participation. And in light of those principles, given the extent, depth, and detail with which demand management had been engaged, both before, during, and after the consultation, this was a circumstance in which fairness demanded that the Secretary of State give those consultation responses conscientious consideration. And remembering, at this stage, all that I have to show this court for permission to be granted is that there is a reasonable, not fanciful,
no, it's a realistic possibility of success. We're familiar with the test, or some other compelling reason.
Prospect.
It's not necessary to worry about the test. That we really have familiar. It's much more sensible to use the limited time on the substantive arguments.
Correct. So, if I may take the court then through those 4 things, and this is from page 3 in the skeleton argument, paragraph 7. And this is indeed, if the court has the judgment open at the same time, all set out or almost all, set out in Her Ladyship's judgment as well. From page 476 onwards.
Yeah.
So this picks up that between 2020 and 2021, there was work that was undertaken in relation to the aviation consultation.
We're familiar with that. We've read all the background documents.
Program,
we've seen the officials' recommendations in the submission.
Yes.
We've seen the handwritten note by the then Secretary of State saying he wasn't going to do that. And then you have the consultation document.
Yes.
So we really are familiar with what happened up to the consultation.
Yes. But the court, what I'm trying to develop is how all of that contextual material, both the private material that was before the Secretary of State, and as I have 10 minutes left, I might just ask the court to turn up 1 page in the supplementary bundle. It's the email on page 4.
Yep.
That's summarising what had been said to the department by the CEO of the Jet Zero Council, the CEO of Heathrow.
Yeah. Was this prior to the consultation?
Prior to the consultation.
And that's her view of what it should contain.
And that's her view provided in a workshop, which was a teach-in on the net zero aviation consultation. Your Lordship sees that in the first line of the email. So it was specifically about what should be in the net zero aviation consultation.
Yeah.
And she says that she agrees with the officials who at that stage were of this view, that it has to address demand management, given the CCC report. So that's the external, one of the external contextual factors I mentioned. The court will have read what the CCC had said. So internally what's being said is, given that, she doesn't think demand management is a good idea, but she said that a responsible government would need to acknowledge that it is a measure that might be needed to be taken at some point. She suggested a last resort, and then this is the part that is left out of the judge's judgment. She believes that this is a key part of our collective partnership, government backing industry and technology, industry stepping up to deliver, that such a last resort will help deliver decarbonisation we need. And she offers support for the wording. And I emphasise that because you will have seen in the Jet Zero strategy, which was consulted on, that one of the pillars, one of the in-principle pillars, was working in partnership. And so this isn't just some part of the context that's a kind of irrelevant, small aspect. This is a key strand, one of the three principal aspects of the whole of the Jet Zero strategy, that the Secretary of State is being advised by an industry-independent entity requires there to be consultation on demand management as a last resort in order to deliver decarbonisation.
Right.
That's a very particular internal factual context.
Yep.
That's bolstered by the other internal factual context, which is that Bayes and HMT, once the Secretary of State had said he was not minded.
HMT is what? Bayes is Business and Energy or Strategy or whatever they now call it. And HMT is which?
Treasury.
Treasury, oh right.
Yes. That Bayes and Treasury had raised concerns about the appropriate handling of the lack of policy and reference to demand management.
Yeah.
That is set out in the judge's judgment in that long summary of the material that went to the minister. Then there's the external context, which is the Climate Change Committee.
Yeah.
And their repeated recommendations. Yeah. Your Lordship has seen that.
They want to have demand management, yes, that's their view.
And then there is the fourth thing I mentioned, which is the backdrop that this is an environmental consultation.
What does that mean? I mean, this is a consultation about certain measures in relation to aircraft decarbonisation.
Yes. It means the Aarhus Convention applies.
So what is the argument? That the Aarhus Convention confers an enforceable right in domestic law?
No, that the Aarhus Convention must be part of the contextual background.
What does that mean, though? So that it's an international convention, isn't
that
it?
means that when the Secretary of State is asking himself, what does fairness demand that I do in this circumstance? It forms part of the answer to that question, that this is a consultation undertaken on environmental matters in which public participation is to be assisted or encouraged, and was a consultation where, indeed, as a result of that public participation, on every single question, a large number of consultation
I'm missing a bit at the moment. The
Demand
Aarhus Convention is an international agreement between states.
Yes.
And I've read the words, or I've heard the words context.
Yes.
I'm looking for the legal mechanism by which you say there is some sort of obligation that this court must police.
My lord, that's the case law that says that you look at the context in which the consultation takes place. I'm not saying Aarhus is directly applicable, and I'm not relying on Aarhus as a freestanding legal principle.
Right.
But I think it's very clear that this government, and the government at that point as well, was very well aware that the Aarhus Convention and public participation is required to be taken into account when the public is participating in environmental matters. It's at the very least arguable that the Secretary of State, as part of the broader context within which this consultation was taking place, was aware that it was an environmental consultation on a key environmental policy, and that there are a suite of international obligations in the Aarhus Convention that facilitate public participation. I put the point no higher than that. It's part of the context.
Right.
And given that this is context, very different from other consultations, that the other statutory consultations or other consultations that the court may have dealt with in other cases, where the internal and external context was as I have just laid out, both independent industry bodies, the Climate Change Committee, and other parts of the state. In the context of all of that, fairness demanded that the demand management responses were given conscientious consideration. We're still even on ground one, with my last 3 minutes left. We're still even on ground three, that assuming the Secretary of State was allowed, was capable, was right to narrow the consultation, if that's what he did, which of course that's not accepted on the document that a reasonable reader would say that, but if that's what he did, that given this context, it's arguable that the fairness requirement was that conscientious consideration be given to the responses.
Right. On that, can I just ask one question? Because I read your client's consultation response. Your client clearly thought that, or that's the impression I've got from the document at tab 18, your client thought that the consultation document was not actually calling for a consultation on demand management. That's the impression I've got from the document.
Yes, different individual responses took different approaches. Some understood the consultation not to be calling for responses on demand management.
Yes, no, I'm wondering what
anyway.
yours did, and your clients understood it as not calling for responses on demand management. Is
My
it factually correct?
My understanding is the clients were confused about what was being consulted on,
but they took the view, page 2 and 8, just so that I've got it clear in my mind.
They took the view, as articulated in their consultation response, that they would go with the most narrow version, i.e. that it wasn't being consulted on, but they would respond anyway.
Right. So they took the view that it was not being consulted on, but they wanted to express views about it anyway.
Yes. Possible took a different view, and indeed
we'll get on to possible. You're not representing them for the moment.
Well, it does go to the context.
Sorry, can I just get the submission correct?
Yes.
Galba took the view that consultation response is not invited about demand management, but made submissions about them anyway. Yeah. Right. That's helpful. Thank you very much.
Yes, as they were permitted to do in the circumstances of this consultation. For all the reasons I've just indicated, it's not surprising that in these circumstances, and as far as Galba, of course, wasn't aware of the internal material
I understand that, yes.
that had been put before the Secretary of
What
State.
I'm looking at is point 2.2 at page 220 of the supplementary bundle, just so that I've not misunderstood what your client was saying. I've read it all, but it says there is a clear alternative evidence-based scenario that the government could and should implement, and that's the demand measures, and they refer to the CCC. And I've read that as them assuming that there was an alternative to what was in the consultation response, or have I misunderstood what they're saying?
You see, this goes to an important point that's relevant to grounds 1 and 2.
Yes.
And it's picked up in the document that possible, and I know it's Possible's document, but it's relevant to this as well.
Can I just have the answer first, please? Have I misunderstood?
It's,
that sentence, am I right to read it?
You can't read that sentence as Galba accepting that it was a narrow consultation.
Right.
What that sentence means, and this is what Possible put into their document, which is before the court, which was the reply document that went before the judge. What that shows is that consultees, including Galba, took the view that they were being asked for their views on whether the scenarios were correct and whether other scenarios should be taken into account. And I mentioned, actually, when I went through the judge's judgment, that I would come back to what she said about the scenarios. And I think it's important because this goes quite crucially to, I suppose, all three of the grounds, but certainly grounds 1 and 2. And that's that if one looks at the consultation document, it seems to positively invite consultation responses that say these scenarios that you have put together, or these trajectories on which the whole of your consultation is based, are not adequate or are not the right trajectories or scenarios. And indeed, you should be taking into account additional trajectories or scenarios, i.e. a trajectory or scenario that includes demand management. And I can just look at, and I'm trespassing on my time. I'm at 42. I'll just take 3 minutes to deal with this. The key part of the Jet Zero consultation document that makes good that submission is 162 in the supplementary bundle.
Yeah, the question's on the first bit about the scenarios, yeah.
Yes.
And is there anything in that page 167 you particularly want us to look at?
Yes. Question 2. Do you agree or disagree with the range of illustrative scenarios that we have set out as possible trajectories?
Yeah.
With the range. The plain meaning of that is there something outside of the range that we should be taking into account? And the answer given by Galba and others was yes, demand management. Then
You'll
next,
have to explain that a bit more. You'll have to take me to what is meant by the range in this document, and then you'll have to take me to the Galba document that says the range is affected by demand management.
but the range of scenarios is, I can take your lordship to every element of this document which uses the word the range, but the range as we understand it is the suite, all of the scenarios, the number of scenarios. Is there another way in which that word can be understood?
I'm just trying to understand your submissions.
Yes.
And as I understand your submissions, it is this. Because there was a question about the range of illustrative scenarios, that brought with it, or left open the possibility of people understood that it brought with it a different alternative scenario, which was demand management. And it would have helped me if you could have related the questions back to, and in particular the range, to something in the document. But
yes, so the range is what is set out above in the document, scenario 1, scenario 2, scenario 3 and scenario 4, from page 160 to page 162. That's the range. And the questions relate back up to that range of scenarios. And as possible, submitted in their reply to the judge.
sorry,
Yes.
it's entirely my fault. It begins by saying we have modelled 4 illustrative scenarios to reach UK net zero aviation by 2050 through different technological pathways.
Yes.
And they've got 4.
Yes.
So do you agree with those? I thought meant, is there something wrong with the way in which they work them out? But you're saying it means something different. You're saying you shouldn't be having illustrative scenarios based through different technology pathways because there's something other than technology pathways, demand management. Is that the submission?
Yeah, my lord, if you read on in question 2, are there any alternative evidence-based scenarios we should be considering? Are there any alternative?
Where's that?
Question 2, page 162.
Oh, no, yeah, so I see, yes.
Yes. Do you agree or disagree with the range of illustrative scenarios?
Do
And
you think that's...
are there any alternative evidence-based scenarios we should be considering?
So you're saying that doesn't mean alternative technology pathways. You think that means things other than technology pathways?
I don't just think that, my lord. That's the plain meaning of those words.
Oh, you submit then. We won't have an argument about words. I'm just trying to do my absolute best.
Yes.
I promise you to understand what you're saying.
Yes.
But your argument is then that a range of illustrative scenarios invited you to say you shouldn't have technology pathways. It should be something else.
No, invited you to say that there is another scenario that one must consider, a scenario with direct demand management or demand management in it. And your lordship did indicate that...
So it's illustrative scenarios. It's an invitation to put forward alternative scenarios other than technologically based ones.
Not... your lord's gloss is other than technologically based ones. Because all scenarios will have technology in them. Just some scenarios will have technology and demand management in a greater degree than other scenarios which have technology with less demand management. The scenarios in this document have demand management measures in them. They just don't have the full panoply of demand management measures that were being asked for by the Climate Change Committee and by others, restricting growth to 25%.
Right, okay. Thank you.
And possible, and I know I've said this a number of times, but it's quite important that your lordship sees that this is not an argument I've just come up with on the hoof.
No, I'm not accusing you of that. It's my fault entirely. It's very important to your clients and generally that we understand it. So that's why we test it, just so your clients understand. We want to work out what it is that's being said so we can work out whether it's got a realistic possibility of success.
Yes.
But I've got what you're submitting now, yeah?
Yes, and if your lordship looks at page 431 in the supplementary bundle.
431, what's that?
That's the possible reply note.
That's in the High Court, is it?
That's in the High Court. Both the claimants put in written replies.
Yeah.
This is part of possible's written replies. Your lordship sees there paragraph 10.
Yeah.
The question, do you agree or disagree with the range? Are there any alternative science-based scenarios? And
hold on, sorry, let me just look at this again. I think there's no more. Which paragraph is that?
paragraph 10.
Yeah. No, as the underlying version of this paragraph, which paragraph is this paragraph?
So this paragraph is the paragraph above,
Yes.
which is 3.41 in the document.
Exactly, yes.
Yes. Read on, if you can, my lord.
Right.
Indeed, question 2
Demand
asks
has been definitively
readers.
ruled out, yeah. And then you've got, yep, okay.
Yes.
So that's what the possible submission to the High Court.
Correct. And your lordship may have picked up that their possible gives SB 192 as the reference. I took your lordship to SB 162. 192 is where the questions are set out in summary.
Yes, they've got all of them,
162
yeah.
is the contextual setting out of these questions, which I...
Right, I've got it now. Thank you very much. That's very helpful.
Beyond. While I'm just in this document, my lord,
Yep.
what we say in relation to grounds 1 and 2, and I really must stop now, what we say in relation to grounds 1 and 2, is that possible here, and Galba as well, brought to the High Court's attention in a lot of detail a number of passages from the Jet Zero Strategy consultation document, which in their submission, which we endorsed, would lead a reasonable reader to understand that the consultation incorporated demand management.
Yeah. Well, we read the document and we've read the skeleton arguments for this hearing and we've read the judgment, yeah.
I'm very grateful. And my submission on that, just going backwards in the grounds to ground 2, the judge only deals with one point that's made in this reply document, and that's where she deals in the footnote with the correct legal policy argument. That was one aspect of this document. Nowhere in her judgment does she deal with all the other parts of the Jet Zero strategy, which the claimants relied on as showing a reasonable reader would have understood that demand management was included within the scope of the consultation.
Can I just ask one question again for clarity? Because I asked it, I just want to be sure I've got your submission on it clear in my mind. I took you to 220 and I asked what 2.2 first sentence meant in the light of that. Yes. And you said, well, you really need to understand it, and you've taken me to later documents, such as the reply and so on. So it'd be quite helpful for this court to understand whether or not it is correct to read that first sentence as an indication that they did not regard the consultation document as inviting responses on demand management.
Yeah. All right. My lord, the reason that I'm engaging with my junior is that for very unhelpful reasons, the document that your lordship has taken me to in the version of the supplementary bundle that I've got, it isn't showing up nicely. I've been looking at the version of the document that was before the High Court. That's not very helpful. That's not very helpful to me because it doesn't give me the references. So if your lordship can go in that document to page SB 230. This document, I'm grateful. 230. It's a bit further down in the document.
Yeah. 10.1, demand management measures should be introduced immediately.
Yes.
That
And that's in response to...
Question 10.
Yeah, and just let me remind myself what question 10 was.
Question 10.
Hold on.
What further measures? It's page 2.
What further measures are needed? Yeah. It sets out the policy proposals.
Oh, that's actually, and that's
Yeah.
right.
And
Yes.
this is the bit on zero emission flight.
Yes. And then, my lord, finally, just to answer your...
So 330, you draw attention to 10.1, yes.
And then in...
230, sorry.
On 2, yes. And what page is it? 224. And then back up to 224, paragraph 4.1. Sorry to bounce around. That's, do you agree or disagree that we should review progress every 5 years and adapt our strategy in response? Disagree.
Yeah.
And just, it's that bit, the sentence at the end. By implementing further demand control measures. Further. So this, as...
So you should assess the extent to which the areas are or not actually reducing the stock. Government policy should rapidly adapt if emissions are not reducing at all or not reducing, by implementing further demand control measures. Yeah.
Yes, further. So further to the measures that Galb already understood.
So your submission is what? That in fact they understood the consultation document
was engaging with demand management and that they should respond on it.
I don't like the word engaging. Your submission is that they understood the consultation document as seeking responses on demand management.
Yes. That's absolutely right. My junior is right. What they understood was that it wasn't off the table. It wasn't redlined out.
Yes. Well, I've tried. I can't do any more.
Well,
Thank you very much.
that is the best I can do in the context of a case where the Secretary of State's case is that demand management was clearly redlined out, was off the table.
Yeah.
And the question in Stevenson is, would a reasonable reader understand that the consultation had, I paraphrase, redlined out demand management? And my response to your lordship is that Galba did not understand the consultation to have redlined out demand management. I mean, the question that the judge asked herself wasn't the Stevenson question about what a reasonable reader would have understood to be wholly outside of the scope of the consultation. That's my colloquialism redlined out. Wholly outside the scope of the consultation. Instead, she asked herself whether the sort of code words that the consultation used, don't restrict flying, the economic and social benefits of preserving the ability to fly, whether it would have been obvious to the reasonable reader that the defendant didn't intend to restrict flying because of those. But that's the wrong question. The question is, did a reasonable reader understand that they were outside of the scope of the consultation? Been going 56 minutes, I understood. And that's paragraph 57 of our skeleton. It's the wrong question that's being asked.
Hold on, let me just get 57.
My lord, as I've been going almost an hour,
Yeah.
and I'm conscious that I'm not the only person speaking.
No, that's fine. You've been very helpful. That was the last question I had anyway. Any other questions?
I'm very grateful. Let me just absolutely confirm that I've gone through everything in a minute. My lord, I'd like to take you just to one document very quickly, and that's in the supplementary bundle, please. In tab well, I don't know what the tab is, on page 254.
Yep.
This is the consultation of summary responses document. It's in the 19th of July document. It's the one we've been talking about a lot.
Yeah.
And if your lordship goes on in that document to page 258, your lordship sees that, in fact, this summary of responses asked itself what the consultation asked.
Yes.
And we say that this is evidence that a reasonable reader, indeed the reasonable reader that put this document together, would have understood that the consultation was not redlining demand management out. And if the court
Anything
reads that
particularly you
first
rely on?
half of, yes, so it's the first half of the page, recognising the important role, that's the paragraph.
Mm-hmm.
We consulted on the proposed framework underpinned by 3 principles, and there's the delivery and partnership principle I referred to your lordship earlier. Then the 5 core policy levers, and that one of the policy levers included influencing consumers to make sustainable travel choices.
Yeah.
One would have thought if this was a consultation, and this is my last point on ground 1, because I haven't really said anything on ground 1, one would have thought if this had been a consultation on how to achieve net zero with the objective of not directly restricting demand management, that this is where it would have been pointed out. And I do say in support of ground 1 that there is nowhere in this consultation document that was put before the public, or indeed the response document that followed up, where it is directly said ever, in clear words, that demand management was outside the scope of the consultation. My lord, unless there's any...
No, you've been very, very helpful. Thank you very much indeed. Mr. Wolf?
My lord, if I could just take a moment to rearrange the furniture.
Yes, certainly, yes.
Thank you very much.
Do you want to?
Back, please.
Let me just get your skeleton.
My lord, my lady, I want, if I may, to adopt Mr. Hon's submissions on those grounds, but as she said, slightly develop them and then go on to 2 additional grounds. In relation to those grounds, the consultation grounds, I want to concentrate on the what was the consultation about question, and I want to distinguish between 2 questions. What is the scope of the consultation? What are we trying to achieve here? And I'm going to say the answer to that is a strategy for net zero aviation. I'll make this good in a moment. How are we proposing to achieve net zero aviation? By technical solutions. So the technical solutions are not the scope of the consultation, they are what is being proposed to answer the problem that's being addressed. And I do that, if I may, through the prism of what I'm going to loosely call the Stevenson approach. The entry to this, if I may, if you pick up the judgment for a moment, please, tab 30, page 508, page 128, sorry, paragraph 128.
Yep.
You see there that the judge explains that the defendant referred to Stevenson as a test of what the reasonable reader would have discerned from documents. That is a reference to Ms. Ward's speaking note, which you then have, I'll go straight to the internal page of it, it's page 386 within that.
Of the core or the supplementary?
Of the supplementary, I'm sorry.
Yep.
And there's a square box with paragraphs internal 34 and 35. And paragraph 35, the government can, as the defendant did here, choose to undertake consultation on a particular strategy. In such circumstances, the requirements are well known. Those principles apply to consultation responses that are within the scope of the consultation carried out, applying the standard of what a reasonable reader, considering the consultation prompt, would have understood. Stevenson. Now, so that was their reply, their response note. We replied to that with a document you have at page 427, in which we, in reply, did what we called the Stevenson response to their raising of Stevenson as the test. Now, the judge obviously we didn't explain well enough to the judge what that document was doing because she was concerned about it. This is paragraph 117 of her judgment. But we say it was a clear response to the way in which the test was being proposed by the defendant as to the scope of the consultation. And in that document, I won't take you through the document, but it did the analysis. It referred to paragraphs of the consultation document, which we say identified what the reasonable reader would understand to be the scope of the consultation. And if I can just pick up a couple of those references, if I may, page 151 of your supplementary bundle.
Yeah.
In the foreword, what we say the understanding of this document is that this is consulting on how to achieve jet zero aviation. And so in the penultimate paragraph...
Hold on. How to achieve...
Jet zero aviation.
How to achieve, well, I'll call it net zero in aviation.
Net zero aviation. And what was being proposed to meet that objective was technical fixes, but what was being asked about...
Hold on, sorry, much too quick. Sorry. And what was being proposed to fix it was technological measures.
Exactly. So penultimate paragraph on 151, this consultation sets out our plans to take this even further through a strategy to deliver net zero aviation by 2050, or jet zero as we call it.
Because I was writing that down, I wasn't reading. Where are you taking
last for one paragraph on 151?
Yeah.
And then over the page, 152, the last paragraph there in the foreword, this is your opportunity to help shape our strategy and give your perspective on how we decarbonise the aviation sector while continuing to benefit from connectivity, jobs and economic benefit. We encourage you to respond. And then in the introduction, page 155, paragraph 1.3, last 5 or so lines, 1.3, by providing the right policy framework, we will support UK aviation, etc. And then in 1.6, we want to set an ambitious framework to support the aviation sector to decarbonise. This framework is what our Jet Zero strategy will set out and what we're seeking your views on through this consultation. And then there's more in the...
Just pause. I've read this and I've marked it. I just want to read it again, but there's more to be done. We want to set an ambitious framework. Is what I would do read on this consultation, yeah? We're committed to the reduction, proposing a set of policies, and the policies span 5 different measures, and they're set out, yeah. Yeah.
And then, in a sense, to jump to the end...
But they're consulting on these particular policies.
Yeah. They're consulting on particular ways of achieving Jet Zero. They have got proposals. So I'm distinguishing, and in my submission this is a necessary distinction, between we are seeking a strategy on net zero aviation. That's the strategy, right? We have a proposal for how to do that, which includes some particular elements.
So you agree that they're consulting on the second, the proposals?
They are. They are proposing those
so
as
they're
their
consulting
solution.
on the how rather than the
strategy. Exactly.
But aren't they being a bit more specific than that? Isn't that what this is saying? We're consulting on these particular methods.
But they're not precluding you coming along and saying there are other ways of doing jet zero aviation which are preferable.
No, they're not. They can't. They're a government. You can write in tomorrow and say you've got this completely the wrong way round. It's a democracy. Everybody can campaign or write in or stand for Parliament. The question is, what was this document asking for? Not because they couldn't do it, stopping people saying it.
Now, this document is asking for your views on our proposed way of meeting jet zero aviation, seeking as we are the right policy approach. That's I think
asking for the views on government's policy.
On the proposed way of meeting jet zero aviation.
Well, it's not.
So they weren't.
Okay, but there's a list of 5 specific.
There is, but what they're not doing, and we say that Stevenson sets out what would the reasonable reader think was the scope of the consultation. What are we asking for? We're asking for your views on our proposed way of meeting jet zero aviation. Not precluding.
No, I understand that. They haven't precluded anything. It's a democracy. They can't stop people saying what they want in any forum. So I'm trying to work out what they're actually asking for. To give it a simple example, they could have said, we want to cut net zero. How do we go about this? We've got these 5 ideas. You might have some more and better ones. That would be one document. Or another document might say, we want to know what you think about these 5 things. And there are all sorts of variations. And the question that we're struggling with, and you might say it's the wrong question, is what was this asking views on, rather than is there anything that says you mustn't say something?
What it's asking for your views on, and that's why I pick up the words from paragraph 1.3, is the right policy framework. The right policy framework. So I'm not as ambitious as my lord's sort of it's a democracy point. I'm not saying anybody can write what they like on a piece of paper. That's not the scope of the submission. The scope of the submission is they are seeking responses to achieve the right policy framework.
But that's the question, I think, because a lot of this is saying it wasn't precluded, and therefore people could say they could comment on anything, and they can. The question really is not what was precluded, but what were they seeking views on. Yes. And you're saying it's the policy strategy, not the specific proposal.
No, they are seeking views on those proposals, but as a proposal.
On the policy strategy and the proposals.
Exactly. So it's not about what's precluded. That's the wrong question.
Yeah.
And it's not about whether the reasonable reader would have understood that demand management was being positively proposed, which was the question the judge asked.
The consultation on the strategy and the proposals for achieving the strategy.
Exactly. So it's not say what you like, it's not what's precluded, and it's not, which is the judge's version, were they positively asking for questions on demand management. It's none of those. But none of those is actually the right question. And that's why we say the Stevenson question is the important one. And the references in Stevenson, well, let me go to it very briefly. It's in tab 15 of the legal materials bundle.
Yeah.
And it's paragraph, it's page 247. And it's paragraphs 43 to 52 and then 58. And this was in the context of a consultation on the national policy framework.
So what I mean, we start with the submissions. What are you actually drawing? I mean, it's not binding us anyway, but what are you saying are you drawing to our attention?
What the defendant was doing when incorporating that, this is by letter B, paragraph 43.
Yes.
And then the issue, and I don't want to take you through all the paragraphs, but the issue that Mr. Justice Dove was dealing with was what would the reasonable reader have understood to be being asked for?
Let me just read this. Yeah, I need to understand much more about that paragraph to know how useful it is as a general principle.
I'm sorry, I haven't got time in a sense to unpack this, but I simply say that what is set out there is an approach to understanding how you understand the scope of what is, as it were, allowed for, not invited, not precluded, not all those other different formulations. What is allowed for in responses that will be being considered. And here,
can I just ask a really basic question? Let's say this test is satisfied, and a reasonable reader might think that consultation responses may be made that include direct demand management. Can you just explain for my benefit what follows from that? In circumstances where the Secretary of State has in fact decided not to.
That's why these paragraphs matter, because in Mr. Justice Dove's case, it was clear that the Department and the Secretary of State were not. They weren't internally looking for views. That wasn't their intention. But he rules out. He puts aside their subjective intention. So it's not about what Mr.
No, sorry. My question's more fundamental. What does it really mean? What's the consequence? Why is it material?
Oh, because that then sets the scope of the responses that the Secretary of State needed conscientiously.
Put it like that. If the Secretary of State has decided, I only want to know about the 5 proposals, I'm not interested in demand management, say that was his stance, and you would say that's what it was.
If that was...
Say that was his stance. People up and down the land think, gosh, at last, my chance to say what I think about net zero, and they do so. And the Secretary said, well, that was a waste of time. I should have told you. I'm not consulting on that. The point is, he's wasted everybody's time, but how does it render his decision to adopt the strategy?
So it's the issue he should have told you. If this consultation document...
And what's the consequences of not having told you?
The consequence of not having told you is that you, the reasonable reader, understand your response on demand management to be, in our case, a frequent flyer levy, to be in scope.
Assuming that's the case, and he's misled you, and he shouldn't have misled you, and you've got it wrong, and you've wasted a lot of time and effort, and you've built up a lot of expectations, at last you're going to have an opportunity to influence the government on demand management, and the government says, well, that's a mistake. That's not what I meant.
There's a distinction between what's being said privately and what's being said publicly. The Secretary of State here, we've seen the red annotations. He'd taken that view. What matters for the fairness of the consultation process and the scope of the conscientious consideration is what's in the public-facing documents. It's irrelevant for those purposes what is said in the on the annotations on the report.
But take all that as read. I'm still not sure I've got an answer that I understand to the question, which is what then happens? What is the consequence?
The consequence of that is that the Secretary of State, when he came here to consider the responses, needed to be briefed on and take into account properly made responses to his properly understood consultation.
Hold on, needed to be briefed on and properly take into account.
Properly made responses.
Hold on, into account. Properly made responses.
Which ours was.
Yeah.
To the objectively understood scope of the consultation process, which we say here was we want to get the right strategy.
Okay, so if I've understood that correctly, the effect of what you call Stevenson applying is to have broadened the consultation. In substance, because you're saying now he's got to think about all this stuff, even though he's previously taken a decision to that by definition the reasonable reader doesn't know about, not to proceed with that as an option.
Yes, I'm not sure I quite that characterisation fits, but the issue here is the fairness of the consultation process.
No, the issue is, was the decision to adopt the net strategy lawful? That is the subject matter of the consultation. If there was consultation about a particular thing and it was unfair, then certain consequences will follow. If there's consultation about a particular thing and he didn't make it clear that he didn't want to hear views about something else,
yes,
the question then is, what follows? Does it affect the lawfulness of the decision?
And I say absolutely it does. And I think my Lord's point about, and didn't tell us, is crucial to this, because we absolutely accept, going back to the MP line of cases, that a consultor can say, I am interested in this, issues A, B and C, I'm not interested in issues D, E and F. Absolutely entitled to say that. And if that's what they say, then they are entitled to be kept ignorant of, or not to read, or whatever it may be, the responses on issues D, E and F. But what matters in understanding the A, B and C is what the reasonable reader would understand.
In terms of the lawfulness of the decision, what matters is, has the Secretary of State taken into account the views on the topics that he thinks he wants views on? If he hasn't made himself clear, I don't want you to waste time on other topics.
But that's the
that
point.
may be regrettable, but does it affect the lawfulness?
Lord, it does. It's the point at which we say the court beyond this to grapple with. I do want to go on to other points.
Anyway, so that's it. You say that it does render even though he didn't want to consult about it, because he hadn't told you, and because he made properly expressed views on that, the consequence is that the decision to adopt is unlawful.
Yes. At least arguably so for the purpose of this hearing.
Yeah, we understand
that's my addition to Ms. Holmes' response. Can I then go on to the other two topics?
Yeah.
So this is our ground 4 and ground 6. So ground 4 is about the lawfulness of the Secretary of State's disagreement with the officials.
Let me just get ground 4 in front of me. Yeah. Whereas you're possible, aren't you? So.
You're possible.
Yeah.
So just the legal entry point to this, the judge sets this out in paragraph 88 of her judgment, and it's the Law Society case, which has been slightly developed and evolved in subsequent cases. But about three-quarters of the way down that paragraph 98, which is quoted.
So you're going tremendously quickly, Mr. Wolf. It's very important that you give us, we're only human beings, time to understand. I'm trying to get ground 4, which appears to be at paragraph 5 on CB 153, but you also want me at the same time, without having identified the ground, you also want me to look at a paragraph in the judgment. So let's start with the ground first. Are you looking, or am I looking at the wrong thing when you say ground 4, which seems to be paragraph 5, or is another ground?
I'm looking at paragraph number 4 on page 153.
Right. Let me just read that. Then it was wrong in law to find that the rejection of the advice was a preparatory step. Instead, it was concluded a firm view. It was wrong to say this is rational. It was plainly irrational. Right, okay, so that seems to be a challenge to the decision of the minister to go for technological solutions rather than demand management.
Yes. Yes.
Right.
So can I then pick up, so the rationality point, I'm just picking up for ease of reference in terms of the law, paragraph 88 of the judgment, page 493.
So rationality of excluding DMM, I'll call it DMM. That's what I've a direct demand management, yeah. Total exclusion of DDM, yeah. And you want me to go to paragraph 498?
88 of the judge's judgment.
Yeah.
And within that quote from the Law Society judgment, about 10 lines from the bottom, a dozen lines from the bottom, a decision may be challenged on the basis there's a demonstrable flaw in the reasoning which led to it. For example, that significant reliance was placed on irrelevant consideration, or that there was no evidence to support an important step in the reasoning, or that the reasoning involved a serious logical or methodological error. That's what I'm picking up on as the legal entry point to this. Then, if I may, the factual entry point to this.
But it is an irrationality.
It's a rationality, but rationality has been explained. That's why it's not just
okay.
That's why that matters.
Yeah.
Within the supplementary bundle, then.
Well, you really have to look at paragraph 90 if it's a rationality challenge, because if you're building up to a conclusion that it is irrational to look at technological solutions only, and it is a mandatory consideration to look at direct demand management, you've got to deal with the Supreme Court, which is binding on us, not the Judicial Court. And that's Friends of the Earth.
I understand that, my lord, but it's not quite the point I'm making.
Oh,
so
right.
What we're looking at is the rationality of the Secretary of State's decision to preclude demand management, and I want to take you to where that decision is, if I can.
Well, let's do it that way, yeah. But yeah. Okay, where do you want us to go then?
So within the supplementary bundle.
Yeah.
29th of April 2021. This is page 7.
Page 7, yes.
That's the briefing to the Secretary of State.
Yes.
And so this was officials on the basis of their understanding of all of the issues around risk and deployability and so on of the technical issues. And that paragraph 8 on page 8, they then say this: to support this, we recommend consulting on deploying measures that constrain supply as a last resort. So they're not saying demand management as one of your primary policies. They're saying we need to consult, recognising that we will aim for technical fixes.
Well, but they're not saying we need to consult. They're officials. They're saying we recommend consulting.
No, they're recommending, yes.
On that. That's their recommendation, yes.
And their reason for that is in 8A.
Yeah.
Because it's, they're bold, a credible pathway to net zero.
That's their view, yeah.
Technologically led pathways are promising, but there is no guarantee of success. Yeah. So to deal with credibility and have a credible proposal in the context of no guarantee of success, they say we need to consult, we recommend, Minister, we consult on, yes, technical solutions, but also demand management as a backstop. Now, the Secretary of State comes back to that, and this is the three documents, or basically two documents, tab 3 and tab 4.
Yeah.
Tab 3, his annotation is this: I will never back demand management, we must simply work for tech solutions.
That's the Minister's decision, in fact, yeah.
Yes, and then there's two, not two versions of it, but there's a slightly longer version. page 21,
Yeah.
entirely agree with RC, that's the Secretary of State referring to Minister Courts, so Robert Courts, and we'll see that in a second. And Minister Courts then below, so we see Minister McLean content in the email, Minister Courts not content.
Yeah.
And then in the third bullet of Minister Courts, it says, instead, we should continue to make clear that technology must and will provide the answers. And it's that must and will formulation which then makes its way into the readout, which is on page 22.
Yes.
And what we say is that there is no evidence or logical basis to support the Secretary of State's rejection of the officials' advice. They have advised upon their, and they, as agreed, the witness speaks to this in detail, analysis of all the risks and so on associated with simply going for technical solutions. And their advice is, for this to be credible, we need demand management as the backstop. And he rejects that.
So hang on, what are you challenging? You're not saying the consultation was conducted unlawfully in accordance with gunning. What you're saying is the decision to do one thing rather than another is unlawful.
It's unlawful because
You didn't challenge that.
we absolutely did, my lord. What we've challenged is we've challenged the decision to adopt a strategy which relies entirely on technical fixes.
Okay.
We see the and let me just take you to the next bit of this. The judge, her analysis of those materials, she explained, we say correctly, that sets the position, and I'll show you two references for that if I may. The first is her paragraph 64.
So you are actually challenging a decision to adopt a decision on technological methods only.
Yes.
So what you're saying, whether he consulted on it or not,
This is not a consultation.
it's irrelevant to the consultation.
Yes, the judge's conclusion was that it wasn't irrational.
Yeah.
Yes, that's what I'm going to come to in a second. I'm going to come to that in a second.
Yeah, but the decision manifests itself in the adoption of the strategy.
Exactly.
Yes, is what you're saying.
The lady has it exactly.
Yeah.
Right.
So then at 64, paragraph
Hold on.
64, line 4. The defendant rejected measures related to the DDM and maintained his position as a red line through the process. Now, this matters because of the way the judge dealt with the point. So she correctly, we say, identifies that at that point, the Secretary of State dug in, my words, red line. She then again comes back to the same thought at paragraph 130. Sentence or small paragraph at the end of 130 after the quote. He and the aviation minister had already formed a firm view against it. Mm-hmm. So she says, and we agree, that at that point in April, May 2021, the Secretary of State formed a firm view against it. We say that that firm view, and she appears to agree, propagated through and became the operative final decision.
Yeah.
From that point on, he wasn't listening to demand management suggestions, whatever they may be. And
No, we're taking a policy decision.
we challenge that. We challenge that, absolutely. We challenge the lawful of thatness of that. And we say, look at the point at which he takes that decision. It's on that page.
So on which page?
Page 21 and 22, 21.
Yeah.
We say, what is the rational basis for his disagreement with officials who have provided him with their summary of their detailed evidence-based...
That's how government works. They get advice from officials, then the ministers look at it and says, no, I don't agree. I don't want to restrict flying. I think Britons should have the opportunity to fly. And he thinks the technological measures will work and have to be made to work.
So on the restrict flying point, Possible's consultation proposal response does not restrict flying. It's not like...
We're not on about the consultation response, we're on about a different point now. Whether it is irrational for him to say that he's going to go for technological measures in his strategy rather than demand management measures, using those terms broadly.
And so the civil servants have come up with a package based upon, so the aim is to get jet zero aviation. They come up with a package for how we can credibly, their word, not mine.
In our constitution, they come up with recommendations for the minister, and then the minister must decide. You can't go to a court and say, well, 3 ministers said this at cabinet, the rest of the ministers disagreed, and because he's not explained why he disagrees, it's unlawful. That's the process of government policy decision making.
Absolutely, my lord. But what we are entitled to say in my submission, we're entitled to look at the basis on which he disagreed. Of course, he's entitled to disagree. I'm not suggesting it for one split second. Of course, he's entitled to disagree. But what is the evidence that he's relying on to say we can achieve Jet Zero credibly without the demand management as a backstop, which is what his civil servants who've gone through the evaluative process have said. That's the gap. That's the law society gap. The law society gap is. They have put before me a suggested package. I'm going to not follow their advice, but with
just a moment, this is clear from your grounds. Is it in the High Court? Just take me to the grounds in the High Court.
It's page 259 in the core bundle.
259. But it seems to me you would have. Let's have a look. 259.
So it was added by amendment, this ground, because we were only...
Let's just look at it first, shall we? Rather than tell me lots of things about it. Let's just see it. Where is it?
It's paragraphs... It's ground 6.
Yeah, which page on which document?
259 in the core bundle.
Yep. Yep. That's ground 6 in the core bundle.
6. And if I can just take you to paragraph, so 95C.
Hold on. I want us to pause slowly, Mr. Wolfe. I want you to let us have time to read this, and then I'd like you, please, to take us to what the judge said about this.
Okay.
Right, but let us read it first. Failure to read is really right and reject the paradise. So it's 95C, a duty to have and give rational reasons for departing from firm advice of its officials, yep?
Well, and then, so 95C, it's the quoted bit from, it comes in Wells, but it's the same proposition that I just showed you in for ease in the Law Society. Does the conclusion follow from the evidence, or is there an unexplained evidential gap? The quoted passage in 95C. And well, what the minister...
And then, could you show me, please, what the judge said? Because the argument now is that the judge dealt with that wrongly.
Absolutely. So it's the where do we get the must and will? Technology must and will. It's the will that's the problem instead. So the officials were saying no guarantee of success. The minister is now saying it will. Where's the evidence to support the will as opposed to the might and we need a backstop? And the way the judge dealt with this...
Hold on. Yep.
Is that the whole ground starts the foot of page 512.
So this is ground 6 lack of reasons.
Well, she characterises it lack of reasons, but that's not a. I'm not taking a point on her characterisation because.
Well, actually, your 95C is a duty to give reasons, to have and give rational reasons for.
To have.
Right.
So, and the rational reasons include having evidence to support the proposition. So, her answer is in paragraphs 153 to 158, and she basically takes a separate point, not about rational reasons. She takes a point to say that we were challenging an interim decision which didn't yet have legal effect because we were focusing on the documents I've just shown the court. And we say, once you understand...
So one moment, much too quick. Mr. Wolfe, we've got to understand what you're saying. So what you're saying is, she said this ground is wrong because it's focusing on an interim stage in the discussion between the officials and the ministers. Is that what you say she said?
That is what she says.
Right. No, hold on. So the judge wrong because she says the officials, ministers is part of the process, not the decision.
Yes.
Yeah.
To which we say, as the court has seen, and as she, in other places, characterised it,
This was just have a moment then to read 157. This should be in action. Should be to the challenge of the exclusion of DDM in the final JZS. And I'll go on to right.
So
yes.
So we say she is. So she says we should have challenged the final Sydney and DDM. We did. Well, that's exactly what we were doing. But we just go back to the root of where the die was cast, which is where I've shown you, and I won't go back to it. So she then says at 158. So we say she's wrong in her leading up to 158 to reject the ground on that basis. So she
right. But she goes on to say, if I'm wrong on that, it should be in the final thing. Yeah.
So I then go to irrationality, and she says this at 160. As I've already stated, DDM is a controversial issue in which people hold conflicting views. The defendant was entitled to disagree with the advice given to him. Agree. The defendant rationally believed there were effective technological alternatives which were under consideration in 2021. And that's all she says. Now, we say that's not an answer because the minister went from this might work, but we need demand management as a backstop to will work. Page 321 will work. And we said there's no evidential basis for that step, and the judge hasn't provided an answer to it. She dealt with the point in a different way. So that's our next ground, my lord.
Yeah.
And the final ground is this. This deals with the basis for the Secretary of State's confidence.
Which ground are we in?
We're in ground 6 of the Court of Appeal document.
Yeah.
Paragraph 6, I should say.
Yeah. Which let me just get the page. It's very important to be clear. So you're tab 10, aren't you? No, are you tab 10? Yes. And you want paragraph 6 of tab 10?
I do.
Oh, this is, yes, global feedback, yes. It's actually ground 5,
Yes, exactly.
global feedback, yes. And cutting it short, because I've been trying to think, your argument is that all the global feedback case decided was that Secretary of State meant Secretary of State A, not Secretary of State B.
Exactly right.
And she was wrong to use it in support of something else.
Exactly right.
And my next question is, so what? Where does it go on from there?
So what? We had. If I go to our High Court skeleton just for a moment, so we see what we limited things we've drawn from feedback.
Before we go to the documents, it would help me at a very high level to understand what you're saying the Secretary of State needed to do, rather than criticising the judge for the moment. Although I'll let you come back and criticise the judge.
My lord, yes. So what? We say that the Jet Zero strategy was not being developed as an exercise in Section 13 because Section 13 is the exercise for the Secretary of State for Energy Security and Net Zero. That's the feedback point. What we say that was nonetheless being done, which the Court of Appeal in feedback recognised as a situation
that it could contribute towards proposals.
Exactly. That this is effectively contributing towards those proposals. It's an easy effect. Proposals and policies being prepared by Secretary of State for Transport to hand over to Secretary of State for Energy Security.
Which the Secretary of State, for whatever it is now called, could take into account when deciding her or his. Yeah.
Exactly right. Now, what we say is because these are or can be characterised as those kinds of proposals and policies, they're candidates for that job. Therefore, that informs what I'm going to call the Tameside understanding, which is the scope of the information which this Secretary of State needed to have to formulate this as his policy that was going to have that effect.
Now just pause there and go so that possibility that it could contribute towards the performance by a different minister with other duties, conditioned the inquiries for Tameside.
I'm happy with that.
Tameside is a rationality thing. Exactly. It has to be irrational.
Exactly.
Not to make further inquiries. And so what was the irrationally failed to do?
So here what we have is in the consultation document, not a consultation point, I'm just showing you the document. In the consultation document at page 173, there's a section here dealing with sustainable aviation fuels, which is technological fix 1, and then zero emission flights, which is technological fix 2. Here, sustainable aviation fuels could play a key role in decarbonising aviation. And that is the theme of this. They could play that role. Now, nobody doubts they could play that role. Likewise, zero emission flights, which is page 177, para 3.21, could support. Nobody doubts those as possibilities. The issue is how likely they are. How likely is that we will have battery-powered jumbo jets within the foreseeable timescale?
Well, he's got to make a judgment on that.
He's got to make a judgment on that, exactly. And we say the reasonable Secretary of State would ask for information on that likelihood.
But that's what he's...
Well, that's what he's done, that's what the Constitution is.
Sorry, no.
That's what the consultation is about.
Well, that's what the consultation is about.
Are you leading up to, I think you must be, that to fulfil the Tameside duty, he's actually got to ask about demand management?
No, I'm not. No, not at all. No.
And I don't.
Sorry. What I'm saying. So perhaps I go back to our amended statement of facts and grounds, which is tab 15 in this bundle. Sorry, I mean tab 15 in the other bundle. I'm sorry.
I mean, if he's got to ask about these things, how realistic are they going to work? As my lady says, that's what the consultation document is about.
Yes, and I'll come in a moment to what the judge says the answer to this is. But there is no evidence. There was no evidence before the judge, and there is no evidence before this court about information telling the Secretary of State how likely or unlikely those coulds were to eventuate.
No, you've just told us this is a Tameside duty. Although we use labels, what that means that the level of inquiry that the Secretary of State undertook was irrational. So you need to look at what it is that the Secretary of State has asked about. And you're saying there are lots of coulds with the sustainable aviation fuels, battery-powered aircraft, and you've got to ask and get information about how likely that is. Well, we're told, and we haven't gone through all the meetings he's had with all these industry bodies and climate change, but the bottom line is, the one thing he certainly did ask about is what people thought about sustainable aviation fuels and battery-powered aircraft and things. That is a manifestation of.
And what he got, well, so in a possible response, which he seemingly didn't consider, it's replete with repeating the proposition that these are nascent, untested and unlikely to succeed technologies.
That's their view.
And, absolutely. And what we don't see, and I'll come to what the judge identified as being as the material reliable in a second, what we don't see is information going to the Secretary of State from officials or from consultation responses or anywhere else about the likelihood or unlikelihood of those things happening.
It's for him to determine, subject to rationality, what further information he needs. He's met the industry people, he's got the advice from officials, and he's consulted on these things, and he says, that'll allow me to form a strategy. And that's all Tameside requires.
I understand that, but what I'm saying is, no reasonable Secretary of State, faced with the proposition that we are relying on these technical fixes to achieve something which is time limited and parameterised. This is net zero aviation by 2050. This isn't some abstract sort of target duty.
It's a duty in law.
It's a duty in law, but his version of it is a parameterised thing. You could put numbers to what he says this strategy is going to achieve. 0 by 2050 for aviation. That's a very calculatable thing. He's being asked to adopt, and he in the end adopts, technologies as the solution to that, which the information before him says could do that. We say any reasonable Secretary of State would have asked how likely is that to be the case, particularly when faced with consultation responses like ours, which are saying it's very unlikely. And let me just then finally pick up the judge's response to that.
Yeah.
Because the judge's response to that is... I've now lost my reference. The judge's response to that is in paragraphs 104 to 107 of her judgment. And 107 is the crunch point where the judge finds the evidence, if you like. She says this: there is ample evidence that the defendant and his officials, the and his officials is not legally relevant for that purpose unless it's conveyed to the minister, considered the deliverability of policies in the Jet Zero strategy and had warnings, etc. Timescales were also considered. Ms. Grieg draws together the main points under the heading consideration of delivery risks and uncertainties at Grieg 1/96 to 105 and 1/108 to 111. Those, my lord, you have those in page 127 of the core bundle.
Supplementary or core?
Did I mean? Supplementary, my lord's absolutely right, I'm sorry. Within those, starts at 127. What we see, I'm just going to pick up the, if you like, the highlights of what Ms. Grieg is saying. She picks from the document. So para 104. The end of the opening paragraph. Last two lines of the opening paragraph of 104. For the high ambition scenario, the annex noted there are several deliverability challenges associated with this scenario. And then at the foot of the page, will also be challenging. And then in 108, last two lines, successful delivery of changes on the ground requires active management of delivery risks. Those are the highlights. So he knows that there are risks, but there are risks in anything. He's not given any sense of the scale of the risk. Is it a 1% chance we're going to have battery jumbo jets by 2050? Or is it a 90% or a 50%? And we say that matters if what you're going to do as a Secretary of State is to conclude that these things will, and that was his word, work. We say any rational Secretary of State would have wanted information on what I'm going to call likelihood. And that's the point.
I've got one question on you on a different ground, so if you finished with that ground...
I think I have.
And it's really just to make sure that I haven't misunderstood what your clients are saying. Because when I read your, and this is to do with the question of what your client understood the consultation thing to be about. And I fully understand that it's the reasonable reader, not just your client. But when I read your client consultation response, again, the impression I got, and you'll tell me if I misunderstood it, is that the one thing that you knew and were complaining about was that it didn't include demand.
We were complaining they weren't proposing demand management.
Because I was just looking at 201 of the supplementary bundle.
Yes.
The first main paragraph on that page, which begins, it is very concerning that the government refuses to consider the one measure. So it seems to me, when I read that, I thought, well, gosh, whatever the reasonable reader might have thought, this reader clearly thought that it didn't include demand management, and that's why they were complaining about it. Or have I misread it?
My lord, you have to take this in the context of the whole document. If I go back to page 200, summary, under the word summary, the government's recognition of the need to tackle the aviation emissions is welcome.
I haven't found that.
Sorry,
199 summary about possible summary. Oh yes, I've got it. Yes.
The government's recognition of the need to tackle aviation emissions is welcome, but the Department for Transport strategy, as set out in Set Zero, to achieve net aviation by 2050 is dangerously flawed. It relies on undeveloped, etc.
Yeah.
So that is confronting directly that this is the strategy you're asking about, but this strategy is flawed. This strategy is flawed. And it then goes on to explain why the strategy is flawed, because you are only proposing technical fixes, and we want you to listen to this other thing. That's not...
That's the point, though.
Yes, but only proposing to deal with your strategy. It goes back to where we started from. They are not... They wouldn't have... They're not wasting their time. They don't think they're firing in the dark, wasting their time saying these things because the government's... because this exercise is futile. They think this exercise is pointful. They write a detailed response addressing...
Mine is a much more basic question than that. I'm just trying to understand the words on the page, actually. And it may not matter ultimately, because it's a question of what the reasonable reader or what the court, in the position the reasonable reader, thinks. And I'm just trying to understand, did they think this consultation document was asking them to set out their views?
Yes.
Or did they think this is hopeless? What they're proposing is rubbish.
Set up...
And they ought to be doing something different from what they're asking.
There's at least two layers in what my lord says. There's something different to what you're proposing to deal with the problem that you've identified, which is Jet Zero by 2050.
The question that I'm trying to ask is, what did they think this document was asking them to comment about? Not what they thought should be asked, or what they wanted to say. What did they think this document was asking them to comment on?
the government's proposals for meeting Jet Zero aviation.
Right, okay, that's helpful.
And the proposals were technical fixes.
Yeah.
And they said technical fixes part of the solution, but more is needed.
Yeah, that's their view. Yeah. Right, that's helpful. That's what I thought it meant.
Lord, unless I can assist.
No, that's very helpful. Thank you very much. Yes, Miss Ward.
My Lord, my Lady, unless there's anything on which I can assist you specifically, you have our submissions in writing on the issue which we were asked to address, which is the Secretary of State's position on conscientious consideration. I hope that's reasonably clear from the short note that we provided. The Secretary of State was...
Sorry.
So I don't want to interrupt
No.
the debate between my Lord and my Lady. The Secretary of State was not required, we said, and the judge accepted, and we say for reasons that are impeccable and fully set out in her judgment,
Right.
Was not required to consult on direct demand management, did not consult on direct demand management. The judge dealt with the reasonable reader point. If it assists my Lord, my Lady, to have that reference, it's at 132 to 133 of the judgment. There was therefore no obligation for the Secretary of State to consider the responses that referred to demand management. It is the case that perhaps in defence of the responsible civil servants who were aware that they existed, we did make the point that civil servants looked at them and considered them, but we never said that the Secretary of State himself addressed his mind to that issue in 2022. We did, of course, say that the next Secretary of State in 2023 did. That decision, informed by consideration of the response that had been given in 2022, was the subject of a separate challenge by Possible, and it was dismissed, and there's no appeal against that. So we also...
Was that challenge on the ground, for example, that the Secretary of State couldn't, when they reconfirmed the strategy in 2023, have reached that view because it's all, if you'll pardon the pun, up in the air as to whether the technologies will work or not? I mean, if you don't have that information at hand, it's very hard.
Well, there were a number of grounds, but the fundamental point is that that decision was found to be lawful, and one of the grounds on which it was challenged.
So the substance of the strategy was decided again and hasn't been found to be unlawful.
Yes. Also, specifically, the decision not to include direct demand management.
And as you say, the consultation responses which were not taken into account by the Minister the first time round,
yes,
you say were,
yes,
the second time round.
yes. So the new Minister wanted to look at it fresh, and that's
So the new Minister looked at the DDI management comments in the consultation responses. Is that fair?
the new Minister did, yes. It's right to say there's no finding, but that's in the evidence. Not the evidence.
But if there's no finding, we're not looking at the evidence now. We're only a permission.
No.
We can't do that.
No, of course not.
So we don't know then.
There was a challenge to the lawfulness of that decision.
Yeah.
Okay, that decision has not been found to be unlawful on any
That's
ground.
all we can go. Yes, we can't start looking at the evidence.
No, I don't. And of course, that evidence isn't before this court because that decision isn't challenged.
Yeah.
There was a separate statement from Ms. Gregg that settled that out in some detail, but the judge does deal with the second decision. So we said, in any event, this would go nowhere for those reasons. So we've set that out in our note. We weren't invited to this hearing to address any of the other grounds on which...
No, you're only required to be here to address that. It's always helpful to have anyone here so we can listen to them as we struggle through these difficult cases. So if there is anything else, we wouldn't stop you. But if there's nothing else you wish to say in this, my lady, no, that's very helpful. But thank you very much. Right, so Ms. De Horn.
My Lord, I'm grateful. Just on the 2023 review, just to clarify where that raises its head to the extent that it does in the Galba grounds, that's dealt with at paragraph 65 onwards in the skeleton argument.
Hang on.
Underground
the
3.
skeleton again. Because I've got a lot of documents. Bear with me. No, I put the skeleton. Well, I know I've had it because I've been looking at it today. Just bear with me. Possible. Where did I put that then?
Well, my lord, I could short circuit it just to say that there's no finding against us, so the review is no
I've
answer
got
to
it.
the unfairness.
Sorry, I knew I had it, yes.
My lord, I'm grateful. Just to say there's no finding against us on the 2023 review, so it's no answer to the unfairness that we say arises under ground 3.
No, I understand it's no unfairness in relation to the consultation response. If you weren't consulted or, properly and fairly. But hold on a moment. There are two separate things. If the answer to your client's concerns is, well, the minister should have looked at them, well, he didn't look at them in the first one.
Yeah.
But if it's lawful now, if the 2023 one is lawful, they would say, what's the relevance of worrying about what happened in 2021 or 2022? The strategy is the strategy in 2023.
The 2023 review doesn't solve the unfairness that took place in 2022.
No, I understand that. If
Yes.
you're right and there was unfairness, there was unfairness.
Yes.
But
Yes, correct.
you're not getting a remedy. We were treated unfairly. You're getting a remedy or seeking a remedy because a strategy was adopted which was unfair. And the reason why it was unfair, you say, is because you were at least not precluded, in the way you've put it, from expressing demand management views, and they weren't considered. But if in fact they were subsequently considered...
Yes, but they weren't subsequently considered in a way that remedies the unfairness. That's the point. There's no finding.
No, I understand there's no finding,
No.
but there's no ability to challenge the later one on the grounds of unfairness.
Yeah, but that's not the point. What the point is that the later one is, to the extent that, and it may not be being used in that way at all. It may not be being used to say we get no remedy as a result of unfairness in the 2022 consultation, 2021-2022 consultation, because that unfairness was dealt with in the 2023 review. If it's not, that's not being, as I understand it, that's not being said. Well, certainly there was no finding by the judge on that point in her judgment at all. So there's nothing that assists this court either way on that in the judge's judgment. She just didn't go there.
But you want to challenge the lawfulness of the decision of Mr. Shapps to publish the jet strategy document.
Without conscientiously considering.
Without considering it. Well, hold on. No. Judicial review is a claims challenge decision, CPR 52.1.
Yes.
Hundreds of years of law. The decision is to adopt the strategy. The next question the court will ask, when you've told us what you want to challenge, what are the grounds? And the grounds are, well, the minister should have looked at our responses and he didn't. And you say, well, that's fine. So we'll cost the 2022 strategy if you're right. But if in fact there's a new strategy in place, or a strategy that was the same as the old one, being confirmed, and there's no challenge to the lawfulness of that strategy, and there's quite a lot of authority, well, there's two big Court of Appeal cases, saying that if there was an error when you did it the first time, but you've corrected it the second time, then it's all right. There's an environmental case involving the environmental duty just a few months ago, and there's a case, I think, called MTS, that says even if there was a failure first time round, if in fact the strategy that's been adopted looked at everything and isn't unlawful, then that's that. It doesn't solve there being a breach, but there's no need to grant a remedy in relation to the current one.
Well, in the context of consultation, that's not the relevant case law, and we've set out in our skeleton argument what the relevant consultation case law is about an argument that the unfairness at the first stage is effectively made good by a later decision at the second stage. That's not the correct approach in relation
What are you referring
to consultation case law, and that's in our skeleton argument. Yes, 51. Forgive me, it's Dudley. I knew it was that.
Well, that's section 31(2)(a), yes. But that's a slightly different point. That's well established, and there are 2 court of appeal authorities from earlier this year on precisely this point. But leaving aside the fact that none of the cases are being referred to, that's a slightly different point. I'm not saying refuse a remedy in relation to the first one on discretionary grounds. I'm saying that the current policy is included in the 2023 approved document, and that did take account of it. So there's no unlawfulness in relation to that document that needs to be remedied. Whether you get a declaration or anything in relation to the first one is another question.
Yes, we're not saying anything in relation to the 2023 document. That's correct.
But if that's a lawful document, what's the purpose of quashing the 2021 iteration?
Because it was unlawful.
But it doesn't matter because it's not the one that applies now. I thought the 2023 applied.
Yeah, no. Correct. Yeah, that's right. Yeah, that's right. Yes, so Galba's and Possible's approaches on the 2023 document were different. So the 2020...
What will decide anything that the government does on net aviation emissions? Is it going to be the 2023 document or an earlier version of it?
On Galba's case, it's not the 2023 document. That was a side review that didn't change, that effectively confirmed the earlier decision. It wasn't a freestanding, separate decision. And that's why Galba didn't bring a second judicial review claim. Galba never challenged that as a new, separate, freestanding Jet Zero strategy. What 2023 did was a review in, we say, an unlawful, well, in a fashion that didn't solve the unlawfulness of the 2021 document. The extant Jet Zero strategy, that is the Jet Zero strategy that everyone is referring to and is being relied on in decisions by the Secretary of State and by others now, is not the 2023 review decision, it's the 2021
or 2022
document.
Yeah. Okay, right.
So that's why
Galba's position.
it's important that the 2022 document is quashed, and the 2023 review, not a new document, doesn't solve the problem.
Right.
My lord, that's Galba's position on that.
My Lord, we adopt that and just reinforce the point that my Lord identified earlier on, which is the judge didn't find that there's no finding by the judge that a later review decision cured defects in the first one, and that's the crucial point from our point of view. The other point that Ms. Ward referred you to is paragraph 132, which is where in the judge's judgment, where she said the judge dealt with the Stevenson point, and that's right, that's where the judge did deal with the Stevenson point. And when we say she got it wrong, line 5, towards the end of the line in 132, in accordance with good practice, the consultation document gave consultees an opportunity to suggest alternative approaches, but there was nothing to suggest that consultees were being invited to respond on DDM. Well, that's right, but that's not our case, and that's not what Stevenson says. You don't need to be invited to respond on DDM for DDM responses to be within scope of alternative proposals to deal with the Jet Zero strategy question. That's where she gets the Stevenson question wrong. We are not contending she was positively asking about DDM, and we don't need to. That's the point.
Then I am confused. I understand that Mr. Horn's case was different from yours, and she used the words precluded, and there's nothing to preclude. And if there was nothing to preclude, you assume it's all in. But I thought your case was slightly different.
Yes.
That this was a consultation both on how to achieve the why, the how and the why.
Yes, but
it is a consultation on strategy.
It's the how. It's the how. How to achieve Jet Zero. Exactly.
It covers how, not just.
No, yes, but the scope of the consultation for Stevenson purposes, which what the judge asks herself the wrong question, is and I'm repeating myself now. We wanted a policy on the right policy for Jet Zero aviation. We're proposing to do it by A and B, and we come along and say, well, hang on a minute, A and B will get you some of the way, but you also need C.
But you are saying, I think, that you are positively invited to comment on the question of how to achieve it.
Yes, yes. Yes, that's the right. We're trying to. I'm paraphrasing, but not far from what the words actually say. We want the right policy on jet zero aviation. Tell us whether we've got the right policy. And their proposal was.
Yes, so you're saying that she's wrong. I mean,
absolutely.
They were invited to respond on DDM, and the way they were invited to respond on DDM was it's a subset of the tell us what the right policy is.
Sorry, maybe I'm over-reading the words she uses, but the way by our reading of what she's saying there is you weren't specifically asked for what about DDM, and we don't say we were specifically asked for what about DDM. That wasn't the question, but that isn't the issue.
No, I think it is just a question of playing with words. Yeah, right. We'll just retire for a few minutes to decide where we're going. There's the other application as well in relation to costs. So let us retire for a few minutes to decide where we're going, okay?
More water.
Yeah.
Yeah, sham consultation. You really misunderstood it. No.
Brilliant, thank you. Right, who needs water? I'm coming on for the first
You first. You procure it. You.
So I'm doing small cups, so we all get some. Right, okay.
Oh yes, that's a good idea. Sorry, I was.
You know, Steph? Proof. You should set up.
Yeah, that's. I like your assumptiveness.
Enthusiasm.
You haven't got enough space. You'll have to clear some of this.
Sorry, I'll put this on there.
Can you just hold that a second, please? Hold Steph's book. Yeah, and then I can put this down here without crushing a computer.
Thanks.
Mr. Spread.
Okay, yeah. Don't crush anything. That would be better. Sorry, got it. Nobody's met on with the answer yet. That's annoying me. keeping me from the realisation. No, it's a readout. exact opposite of sustainable development. We're going to leave this very important price of project to be decided on and paid for by our great-great-great-great-grandchildren who will have had no benefit whatsoever from the electricity that we generate from our lovely nuclear power station. It'll be their problem. Well, that's just a separate problem. No, that's a separate. This isn't about the weight. No, this is about whether it goes on. The size of the effect is too low. They're built size-wise, 7.3 metres above. So, and they're predicting 14 metres deep. So before they have our great-great-great-grandchildren. But at least Hakeley is what they call a dry site. So it's.
Do they not call size what a dry site?
No, they don't.
This is a wet site.
It's a site that needs a wall round it.
Wet and getting wetter.
Yeah. The site that needs a wall round it, basically, potentially. And a wall that we're built. We're about to find out was a must. Not got permission.
You're wanting permission to.
We're wanting permission to say that they need to reopen the DCO to look at this question of what you do with flooding in 150 years' time.
I can read that.
And not leave it to them. Habitat question.
No, it's on. No, it's on.
Well, they're thinking about it.
Thinking about whether they can deliver a decision for lunch.
Well, they didn't just go out and go,
Country
no,
residences.
come back in,
Yeah.
no.
Thinking about the optics. Give them 5 minutes decision before lunch.
Yeah, they've just got for a sandwich.
They just directly behind. They got
Other side of the the only one I've ever been into was on the other side of the courtyard.
okay.
Yeah.
So they're not going to head back to the office.
Wouldn't have thought so. No.
Here last week. Across the corridor. So I think it must be in the master's corridor. Someone sitting at a desk, mastery work. It's a picture of a bulldog, which must be printed about A-Naught's giant photo dog.
The only time I've been into a court judge's private office was when Lord Justice Ricks invited me to come for a cup of tea with him. Then he also told me in great detail why he wasn't going to give me a reference for keep the silk. Which actually was it was a weirdly humane thing to do.
Something
Because
naughty that you've done? Or?
No, he just basically said you need to do this to improve. And if you do those
right.
things, then you'll.
Right.
It was kind of helpful.
Yeah.
You know, I didn't think that at the time. As you can imagine. He said you could go far if only you did this and did that.
Oh, what? Sort of more commercial cases?
No.
Stop pestering the
How you
government.
advocate, basically.
Oh, I see.
It was really useful.
Was it helpful? Like
He wasn't saying stop things.
No.
The agitator.
No. He was saying, he was saying.
If you want to do that, then do it this way. Okay.
Yeah.
what were his tips? Curious.
So his tip was, what was his tip? It was give the court a solution, give the court an answer, make their job easy. Basically, that's what it was. The answer to this case is this. And then the other thing I've learned from the court is we had a case, Rowan and I had a case where
The live stream is still working.
that was a local
David.
resident.
David.
One of the members of the
David, the live stream is still working.
Oh, right.
So just so you know,
Okay, thank you.
what you're saying is going out.
Okay, thank you.
Yeah, I'm sure you're fine with that.
You're not just talking to these people.
I learned a lot from him because he did a lot of the ghosting and that. And that, so in terms of just making them punctual and short, the sort of stuff I do with all the drafts, basically. And half the time on the first 3 paragraphs, they come out with 10 pages.
Oh, because it's the same slide.
Best bit of drafting is don't start letters read out.
Who's that?
At the beginning.
Yeah.
That's when you draft.
Yeah.
This is the person who came to my dissertation. Dive right into the meat.
Yeah.
Come back to the bits.
Yeah.
Always falls on it. And end up drafting introduction. It's far too long. Dr. Henderson said that. Yeah. You should do that.
Isn't it almost after?
You know, and then but when you've actually written it down, you're much more confident. encapsulate my entire life's learning in a sentence.
3 sentences, yes.
Don't do that. You know, start with the reason.
My killer point is. Is it nearly lunchtime? No.
Yeah, yeah, fine.
Rise
This is the judgment of the court on 2 applications for submission to appeal against the decision of Langje, whom we will refer to as the judge. The judge dismissed a claim for judicial review of a decision of the Secretary of State for Transport to publish a strategy known as the Jet Zero strategy for pursuing decarbonisation in the aviation sector by 2050. The applicants are firstly a charity concerned with climate action, and we will refer to them as Possible, which is the name they use. The second is an unincorporated association of individuals who wish to prevent any expansion of the Leeds Bradford Airport, and we will refer to the second applicant as Galba. In fact, Galba's made the submissions first through Mr. Horn, and then Possible made its submission second through Mr. Wolfe. The essential, but not the only challenge, concerns the lawfulness of the consultation process leading up to the adoption of the strategy. Mr. Wolfe, for Possible, added additional submissions in relation to the rationality of the decision-making process in particular that was undertaken. The background facts are set out in full in the judgment below. It's necessary only to point out the following factors for the purposes of these applications. In about May 2021, the Secretary of State decided that he did not wish to adopt measures that would directly limit demand for flight. He wished to see more opportunities for flying and wished instead to address the issue of decarbonisation by technological solutions. The applicants take a different view about the merits of direct demand management and the extent to which technological solutions can or will be able to address issues to do with emissions in the aviation industry. The role of this court is simply to determine whether the decision-making process was conducted lawfully. That is, that it was conducted in accordance with the principles of public law established by the courts over many years. It is not for this court to decide questions of policy, and it is not for this court to decide whether or not it is desirable to adopt particular measures for achieving a reduction in carbon emission. It is not therefore for this court to resolve any dispute about the desirability or otherwise of direct demand measurement. In July 2021, the Secretary of State published a consultation document. The document is described in detail in the judgment. Paragraph 3.41 said this. 3.41. Nonetheless, even if the sector returns to a pre-COVID-19 demand trajectory, as we have assumed in our analysis, we currently believe the sector can achieve jet zero without the government needing to intervene directly to limit aviation growth. The industry's needs to rebuild from a lower base is likely to mean that plans for airport expansion will be slower to come forward. Our analysis shows that there are scenarios that can achieve similar or greater CO2 reductions to those in the CCC's balanced pathways, which limits growth to 25% by 2050 compared to 2018 levels, compared to a baseline of 65% growth, by focusing on new fuels and technology with a knock-on economic and social benefit, rather than capping demand. Views were then sought on the proposed approach to 5 core policy measures which were intended to achieve the desired policy goal. They were, namely, 1, system efficiency, 2, sustainable aviation fuels, 3, zero emission flights, 4, carbon markets and greenhouse gas removal technologies, and 5, influencing consumers to make sustainable travel choices when booking flights. In addressing the complaints about consultation, the judge concluded correctly that there was no statutory duty to consult on the proposed strategy. She concluded at paragraph 120 as follows, open quotation marks. On this occasion, the defendant had a broad discretionary power to formulate a strategy and then choose matters on which to consult. He was entitled to consult on his strategy for achieving net zero aviation, which is based on the premise that people are allowed to fly and aviation growth is not constrained. He was not proposing a different strategy based on restricting the ability to fly. And further on in the judgment, the judge said this, open quotation marks, in my judgment, the JZS consultation was not a consultation on aviation decarbonisation generally. It was a consultation on how to achieve net zero aviation by 2050, consistently with the objective of not directly restricting aviation demand. In choosing to consult on a strategy to achieve a specified objective, fairness did not require that the defendant also consult upon a different strategy to achieve a different objective. Such an approach would fundamentally undermine and delay the defendant's lawful adoption of a particular strategy. It would also be contrary to the principle expressed in the Cabinet Office Consultation Principles 2018 that consultation should only take place on issues which are still at a formative stage. The judge went on to conclude in paragraph 132 as follows. On my reading of the consultation document, it would have been obvious to the reasonable reader that the defendant did not intend to restrict flying because the document extolled the economic and social benefits of preserving the ability to fly. See the extract set out to paragraphs 46 to 50 above. Importantly, direct demand management was not proposed and it did not appear in any of the illustrative scenarios. In accordance with good practice, the consultation questions gave consultees an opportunity to suggest alternative approaches, but there was nothing to suggest that consultees were being invited to respond on DDM. Many of the consultees, such as Possible and Galba, were well informed on these issues surrounding aviation decarbonisation and used this as an opportunity to promote their own views, including advocating for DDM, despite the absence of any questions on DDM. I observe that this is not unusual in public consultations. Close quotation marks. Against that background, we turn to the grounds of appeal. Galba advances 3 grounds of appeal. Alleging that the judge erred in 1, concluding that the defendant undertook the consultation at a formative stage, 2, in assuming that the defendant was entitled to exclude demand management, and in any event by failing to address whether fairness required the provision of information about direct demand management and applying the wrong legal test, and 3, in concluding that the respondent had conscientiously considered consultee responses on direct management. Possible advances the following grounds of appeal, namely that the judge erred in 1, concluding that a reasonable reader would have understood that direct demand management was outside the scope of the consultation, 2, finding that direct demand management was outside the scope of the consultation, but then finding that the respondent did conscientiously consider responses dealing with direct demand management. 3, failing to decide whether direct demand management was a policy option of central significance that was material to any decision to exclude that from the consultation. 4, finding that the respondent's rejection of advice in 2021 to consider direct demand management as a preparatory step. And 5, failing to apply properly the decision in Global Feedback versus Secretary of State for the Environment, Food and Rural Affairs, 2024, 1 WLR 2393. In our judgment, the judge's approach to consultation was correct and not even arguably wrong. First, there was no statutory duty on the Secretary of State to consult. He was entitled to consider and decide whether to consult, and if so, on what proposals he wished to consult. Secondly, if he chose to consult on particular proposals, he had to conduct the consultation on those proposals properly in accordance with well-established principles. If authority is needed for those propositions, see the Crown on the application of MP versus the Secretary of State for Health and Social Care, 2021 PTSR 1122 at paragraph 35. Thirdly, the judge was correct to conclude that the consultation was not a consultation on decarbonisation in the aviation sector generally. It was a consultation on how to achieve the objective of net zero emissions without directly restricting demand. It was a consultation on essentially the 5 specific proposals put forward as a means of achieving that policy objective. Those proposals upon which he was seeking views did not include demand management in the way that we have been using that term in this hearing and this judgment. That appears from the consultation document itself, as the judge correctly found. In those circumstances, many of the grounds of appeal are misconceived. First, the consultation on those specific proposals had to be considered at a time when those proposals were at a formative stage. It was not necessary to include consultation on other different proposals which were not being consulted upon. The consultation on the particular proposals did not cease to be at a formative stage because other proposals were not included within the consultation. Similarly, the decision maker is required to consider conscientiously the responses to the proposals consulted upon, required, but may, if he chooses to do so, consider arguments that a different set of proposals should be adopted. In the context of this case, he is consulting on specific measures to reduce carbon emissions in aviation, but without including measures intended to impose direct restrictions on demand for flights. He was required to consider conscientiously the responses on the proposals he had decided to consult upon. He was not obliged to consider, as part of the consultation exercise, adopting a completely different policy with a completely different set of proposals. Mr. Hall in particular put forward 4 reasons why, in these circumstances, as she put it, fairness demanded consideration of the direct demand management proposals, as well as responses on the matters upon which the Secretary of State had consulted. 2 was general advice and the views of other government departments given prior to the consultation exercise. With the greatest of respect, the fact that others before the consultation process thought that a different consultation exercise might be consulted upon does not generate any obligation on the Secretary of State to consider consultation views about those matters when he himself had chosen not to consult upon them. A third was said to be what was described as context stemming from an international convention, the Aarhus Convention, which deals with what is often described as environmental consultation. We do not see that any of the arguments about the Aarhus Convention generated any obligation on the Secretary of State here to consider consultation responses to proposals that he was not making. Finally, Ms. De Horn submitted that demand management was an option of central significance. She referred to the fact that other people, officials, other government departments, industry and the Climate Change Committee thought that demand management was a good option. Therefore, she submitted, it was fair, or would have been fair, for the Secretary of State to have considered the responses dealing with demand management. We do not agree with that submission. In truth, the applicants are not seeking to complain about the consultation exercise that was carried out. Rather, they are seeking to complain that a different consultation exercise about a different policy should have been carried out. The Secretary of State was not obliged to do that, insofar as it suggested that demand management was or should have been identified as a policy option of central significance, with the implication that the Secretary of State had to consider it. That, in our submission, is the wrong analysis. We will return to the alternative submission put forward by Mr. Wolfe, that the decision to adopt the strategy itself was unlawful for a different reason, namely that it was irrational not to have regard to that matter. But so far as the criticism of the consultation process is concerned, we do not regard the fact that some people would regard demand management as an option of significance, as imposing a duty on the Secretary of State to have regard to responses dealing with that matter when he himself had not chosen to consult upon it. All of that essentially is what the judge said, reading her judgment fairly and as a whole. The judge had summarised the consultation responses at paragraph 71 to 78 of her judgment. At paragraph 130, she described the consultation exercise as a consultation on how to achieve net zero aviation by 2050, consistently with the objective of not directly restricting aviation demand. She found at paragraph 132 that that would be obvious to the reasonable reader. At paragraph 134, the judge noted that she had summarised the consultation responses earlier in her judgment and the department's response to those. She concluded that that showed that the conscientious consideration of the consultation responses had taken place. That, read fairly and properly, is a finding at least that the responses relevant to the proposals that had been consulted upon had been considered. There was discussion and debate about whether or not the judge was saying that the Secretary of State had regard to the responses about demand management, and it was said that the Secretary of State had conceded that he had not had regard to the consultation responses on direct demand management. That, however, is not the relevant legal question. The question is whether or not he had conscientiously considered the responses to the proposals upon which he had actually consulted. And the answer to that is clear that he had. I turn then to the question of whether direct demand management was a material consideration that the Secretary of State had to take into account. That is, that it would be irrational not to consider direct demand management. That is how Mr. Wolfe phrased his ground 5, I think it was, of the challenge, relying on the decision of the Divisional Court in the Law Society case. The test for deciding whether it would be irrational and therefore unlawful not to take account of a particular consideration is set out in the judgment of the Supreme Court in the Crown versus Friends of the Earth Limited versus the Secretary of State for Transport, 2021 PTSR 190 at paragraphs 116 to 121. People may legitimately disagree and take different views of the desirability or necessity of direct demand management. It was not, however, irrational in the sense in which that term is used in public law, not to take that course at this stage, but to consider instead technological solutions to carbon emissions. We do not consider that the references to the different views expressed by ministers or civil servants prior to the consultation and the decision establishes any irrationality. That is the natural process of decision-making within a government. Views will be expressed and the government minister responsible will ultimately have to take a decision. Secondly, we do not accept that it was in some way irrational to say that technology measures will result in that conclusion, that the goal could be achieved and that the minister acted irrationally by proceeding on that basis. That ignores the broader context. The policy is one that is reviewed regularly and has to be reviewed at a certain date in any event. And obviously, the Secretary of State in that review will have to assess the extent to which any policy goals they have to reduce carbon emissions in aviation are being achieved. It was not irrational to decide at this stage to proceed on the basis that technological measures would provide the means of achieving that policy objective. Finally, we do not consider that the submissions made in relation to the global feedback case assist. so far as we understand the argument, it is this. It is said that the judge failed to identify properly or correctly what was actually decided in global feedback, what the lawyers call the ratio of the case. That was limited to deciding which Secretary of State was subject to the duty in Section 13 of the Climate Change Act 2008. It was admitted that the case did not consider the extent to which the Secretary of State's common law duties were informed by Section 30, and that in some way the conclusion of the judge, or the use that she made of the decision in global feedback, was in error. That was then aligned with a submission that the policy adopted by this Secretary of State might contribute towards or assist another Secretary of State in satisfying his obligations under Section 13 of the Act, and that therefore generated, or as was put in submission, conditioned what were rational inquiries for deciding whether the duty in the Tameside case was satisfied. It was then submitted that because of what the strategy might contribute towards, the Secretary of State should have asked for information about these matters. The short answer is that is precisely what the Secretary of State did. That is why he consulted on those matters and asked for views on them. Furthermore, and more widely, it's clear from the judgment read as a whole that the Secretary of State had made considerable inquiries as to what policy he should adopt. It cannot be said that he rationally failed to make further inquiries. People may or may not disagree with the conclusions that he reached, but the suggestion that it was irrational for him not to make further inquiries is, in our view, unarguable. For all those reasons, we do not consider that any of the grounds of appeal in these two applications have a realistic prospect of success. We do not consider that there is any other compelling reason to allow an appeal to proceed. We therefore refuse each application for permission to appeal. Right, are there any other applications?
Well, there's no need, I think, on that basis to deal with Possible's application.
Sorry, you have to speak up a bit.
Apologies, I understand I was broadcasting inadvertently whilst you were out of the room, so I thought it was picking me up. My lords, there's no need on that basis to deal with Possible's application.
Well, we haven't got to that yet. I'll ask the applicants whether or not they wish to maintain their applications. That'll be a matter for them. I'm dealing firstly with the question whether there are any applications that arise directly out of our decision to refuse permission.
We do apply for the Secretary of State's costs of providing the note and attending today, and we've served cost schedules in each case covering only those amounts. Right.
So your application is for an order that the Secretary of State pay, that the applicants pay the Secretary of State. Right. Each of them pay the sum of 1974.10 pence.
That's right, my lord. I mean, in fact, the Secretary.
And is that amount in each case? Is it?
That amount in each case, yes. Right. And the Secretary of State's cost will actually be slightly higher because we're all on hourly rates and we were listed for 1.5 hours. But
so is the application for a higher amount?
My lord, yes. I'm afraid, as my laptop has given up the will to live, I'm not able to give you a precise amount. I do know that the combined figures for all of us for an hour are £664. That's myself, my junior.
I think we're going to have to make a summary assessment. I mean, I'm very sorry that your laptop has died, and I sympathise with it, but it doesn't avoid the need for you to provide figures. You could use pen and paper. Some of us used to do that.
I was just trying to.
Use a pen.
So it was 1947.10.
Yeah.
Add 332, add 166. That's to get.
So you want to add 498, do you?
Yes. I'm going to.
So that's 17 carry 1. Is that 207.210? Anyone here a maths whiz by any chance?
1947.1 plus 332 plus 166. I've got 245.10.
24510.
For each of them?
Each.
That can't be right. That's £245.
2445.
Oh,
I apologise.
2445. That's your application.
That's my application.
244510. So Secretary of State applies for 244510 as against these applicant. Right. Okay. Well, let's hear what the what the applicants have to say in response to that application, and what they have to say in relation to the cost application.
Yeah. My Lord, we're just checking the maths, which we're not sure is correct, but we understand as a matter of principle, given the Secretary of State was ordered to attend, that they should have the
Yes,
costs of
logically,
attendance.
normally they don't, but since we asked them to
Yes,
attend, they
despite
have
the
to.
fact that the basis for the attendance was really dealt with in writing, that the order was to attend.
But to be fair, they couldn't have known that. We could have asked questions.
Yes, indeed. Indeed. But yes, other than...
Well, we need to solve the math.
Yes,
because
we
if you're not
do need to solve
objecting
the
to
maths.
it. Mr. Wolf has got a PhD in
Well,
engineering.
I
That must have included maths, Mr.
1947
Wolf.
plus half of 664 is 2279.
2279.
So,
Well, I'm tempted to say 2,000 and call it a day,
Yes.
frankly, because it's their fault if they haven't got the figures. No disrespect to
apologise.
them.
No, my
So,
fault entirely.
I'll hear what Miss Ward has to say about, right, okay, well in that case, we will grant, yes, we will grant an order that each applicant pay the Secretary of State's costs, because we're required attendance. It wasn't a choice on the part of the Secretary of State. The application is 244510. The Secretary of State is not in a position to be clear about the amounts. So what did I say, 2,000?
2,000.
So we will order that the Secretary of State pay the sum of 2,000 of costs summarily assessed in the sum of £2,000 by each applicant. So it's clear that Possible will pay 2,000 and Galba will pay 2,000 to the Secretary of State. Right, now any further applications?
No, our application in relation to Yahoo's cost order falls away because it only arose if you granted permission because it covered the cost
Then it would be
of
above
the appeal that's
10,000.
not now happening.
So now it doesn't arise. So is the application withdrawn or do we need formally to dismiss it? Just
I think we can withdraw it.
okay. So and it's only possible, isn't it? Because
It's only possible because
the possible withdraws it just so that we've got it. Withdraws application for variation of Lady Justice Falk's order.
Exactly right. Because it's academic.
Yeah. Well, I'll ask Council to produce a draft order that we can consider. You may want to say in the recitals, in the light of the order, Possible withdraws this application for variation of Lady Justice Falk's order because it's academic, because you may want to keep the arguments for a later stage.
Certainly do.
Paragraph 1 is each applicant is refused permission to appeal. Paragraph 2 is each applicant is ordered to pay the Secretary of State's costs of today, that the preparation and attendance of today, that summarily assessed in the sum of £2,000 each. Okay, is there anything else that we need to deal with? Well, thank you all very, very much indeed, and I wish you all a very happy festive season as we reach the end of a long legal term.